Hi, my name is Nägele, and it's a big pleasure for me to give you this guest lecture for the Australian National University on the invitation of Dr. Jason Grant Allen. It's a big pleasure to do that. Today, we will talk about tokenization of assets from a legal perspective. Because you might have heard that tokenization of assets is done already for some years in a lot of countries actually. But in Liechtenstein, we have a dedicated specific legal framework also covering the tokenization of assets. My name is Nägele, as I said, and I think what is worth noting is that I used to code software for about 10 years. So when I founded my law firm, we wanted to build the bridge between technology and law. And that's what we do now on a daily basis, actually. What is also interesting, I think, is that in 2016, I was invited by the government of Liechtenstein to join the work group to think about regulatory approaches in the blockchain space. We then actually came up with a framework which was enforced or enacted in 1st of January 2020. So we have this legal framework already enforced since 2020 here in Liechtenstein. And what did we do different, if we did anything different? We started to think about what was changed through blockchain technology. And the very interesting part is that if you look at how we normally mitigate risks in the financial market, we do that via financial market regulation. So we regulate intermediaries. They have to follow rules, they have to get licensed. Even the shareholders have to pass fit and proper in most frameworks. So it's a very comprehensive, very dense regulatory regime, which then also these intermediaries are supervised by national competent authorities. In the example of Liechtenstein, it's our financial market authority. And this is necessary because you have to put trust into these intermediaries. If you put money into a bank, you have to be sure that they are able, if you want to withdraw your money, that they're able to fulfill that. And for that reason, we have this very strong regulatory regime. On the other hand, we have something which is called trustless technologies. So you basically have to trust no one. The technology works in a way that it's trustless. No trust is needed. This technology is for the first time ever used for payments since Bitcoin in a way where you don't have to rely on any intermediary. So you can basically send funds from Australia to Liechtenstein within 10 minutes or within seconds, depending on the technology you're using, and no intermediary is involved. The question is, though, what does that mean for regulatory approaches? If you now start to think about where should we regulate, you have to ask yourself that one of the big risks is that you overregulate. So you regulate in areas where technology is able to mitigate the risks without regulation, without having supervision by a central authority. On the other hand, there are a lot of use cases and a lot of companies which tell you that they do something with blockchain technology, but in the end, they're in essence nothing else than a traditional service provider, a traditional intermediary with the same risks. Very recent example, if you provide exchange services like a crypto exchange, and you also provide custody for the customer's tokens, you're nothing like you are a central intermediary. The question is, how should they be regulated? We did that here in Liechtenstein with our Blockchain Act, or also called TVTG, and that's the supervisory part, which is not the focus of today's lecture. The focus of today's lecture is how you can tokenize real-world assets in specific, because that is something which is in that detail and in that way is, as far as I know, only solved in Liechtenstein with our TVTG. TVTG, that's the name for the law. It's also known as Blockchain Act or Token Act. And as I said, we for sure also have a supervisory part. So if you want to provide crypto custody or exchange services, you have to get registered with our financial market authority first. On the other hand, we have a civil law part where we focused on providing legal certainty for blockchain-based or DLT-based transfers, that if you transfer a token, also the represented right is transferred. And we talk about the token container model here. That's how we actually describe and illustrate this technology or this use of technology with our legal framework. In the center, we have a legal definition of what a token is. We define a token as a piece of information on a TT system. TT system stands for trustworthy technology. So that's another definition in our law. We don't talk about blockchain or DLT. We call it TT, trustworthy technology, because we wanted to have a very agnostic approach and a future-proof approach, depending on, we don't know how this technology is actually evolve. But the concept was, if you have a technology which allows you to interact without trusting intermediaries, and this might trigger some changes in the regulatory approach, that is at the core. So that's at the core of this regulation. That's why we also had to come up with a definition of TT systems. And for the listeners who listened very closely, we called it trustworthy and not trustless technologies, because trustworthy is easier to digest than to rely on a fully trustless technology. And this token, as a piece of information on a TT system, should be able to represent rights. So with a token, you can represent rights. You don't have to, but you can. And there is a specific set of rights. For sure, it's not for every right you can imagine, but for almost any right, this is possible. What is also possible, that's why it says can represent, it doesn't have to, because you can also use that container representing no right at all. The example we used in Liechtenstein is Bitcoin. With Bitcoin, the only thing you can do is transfer it from transaction to transaction, actually, but you don't have any counter, like you don't have an issuer, you don't have a claim against anyone. The only thing you can do is transact with Bitcoin. And that is what we call an empty container, or actually an intrinsic container where the value derives from no external or third-party asset. It's really within the container itself. It's only the container is valuable or not, depending on what you think of what value is. On the other hand, we have this extrinsic token, where you have this tokenization of assets, where you have the value is actually coming or deriving from an external value. And we also had to find a solution how you build the link between the token to the right. That's what I already described. And on the other hand, you have to find a link to the people who are actually acting. And that's what we call this TT identifiers. You can also, that's also again very agnostic. So the idea was not to use the term address, because not every technology uses addresses. With the identifier, we identify the individual which is acting. So which rights can be represented? As I said, that's actually almost every right you can think of. There are mandatory laws which hinder you from using tokenization of assets, even in our model, but most rights can be represented within tokens. And as I said, on the right side now, you have the rights, some examples. It's not a list of all of the rights. And on the left side, you find this link via the TT key, which also you can think of a private key and the identifier. Again, we had to do that to be agnostic and future-proof. Now, how we then really do this, and that's, so we can call it the Holy Grail, or the Holy Grail, the real tough tokenization, which is actually really challenging, is tokenization of physical assets. Why? Because In Liechtenstein, we are a civil law country. We have a property law, which has a very specific way how you transfer ownership to a physical object. And if you want to transfer ownership of a physical object, you basically, in most cases, have to hand it over. And the whole beauty of blockchain is that you have a digital twin. That's what tokenization of real-world assets is also somehow described with, that you have a digital twin which you can easily transfer. But if you have a digital twin, you have to somehow synchronize the digital world with the real world. And how can you do that? For example, with a watch as a physical asset, if you want to tokenize the ownership rights. Now, some of you might think, yeah, but that's already possible. We tokenize art since decades, valuable piece of art. What we do is we set up an SPV, so a special purpose vehicle, a company, a limited, for example. Then this company buys the object or the asset, and then the company issues shares. And what you do with tokenization, you basically just issue these shares in the form of token, which is also known as security token. And then you have a tokenization of an asset. But if you do that, that's possible. That's also possible in Liechtenstein, by the way, as one of the first countries also, you can tokenize equity. But the thing is that you have an intermediary in between again, right? You have a company which needs to have a C-level, which needs to be audited with a lot of requirements. In the end, this adds costs, and you don't have direct ownership. What you have is you're a shareholder of a company which then has ownership. And what you want to have is direct ownership to this physical good. And that is possible in Liechtenstein based on our TVTG or on our blockchain act. And now let's have a look at how you can build this link between the digital and the real world, between the token and the physical object. What we do is we have to start with a unique idea of a token. So it has to be a non-fungible token, NFT. So when the whole hype around NFTs came up, we said, like, we discussed it in 2016 or during 2016 to 2020, how we can actually make use of this technology. And NFTs, non-fungible tokens, were the obvious choice when it comes to tokenization of assets, because you have to have a token which is uniquely identifiable. And with an NFT, you have the possibility to add a UID, so a unique identifier. And what you could do is how you uniquely identify a watch. In almost every watch, you have a model number and a serial number. And you can just add this model number and serial number to the specific token, which represent the ownership right to the physical asset. So that's possible. And on the other hand, you have to somehow then build a link between the watch and the token. For the securities lawyers, they might be familiar with the securitization clause. And I came in my PhD, I came up with the idea of a tokenization clause, which is very, very similar. The transfer of rights will only take place via the token, and then you identify the token. There are several ways of doing that. One standard is the ITIN standard, where you get a unique ID for every token. And then you just add that somehow to the physical object. So you can actually engrave it to the physical object. You can also engrave a QR code with additional information, or you give the certificate with the watch. Some companies are already doing that. The idea here, again, is that you want to have this the synchronization of the digital and the real world. And this clause on the physical object is needed specifically in the case where you have a good faith acquisition. So you want to destroy the good faith of a person buying from a person who actually should not sell you the watch. If you're interested to learn more about that, at the final slide there are some book recommendation, and in my PhD I write exactly about that. So if you're interested in these books, just drop me a line and we'll find a way how you can get access to these books. I think the overall concept here is clear. You want to have a way how you build the link between then the watch and the token. So if, for example, if you want to sell me a watch and I will have a look at the watch, I will see, there's something written that I can only transfer rights via some token. So I have to do an additional step. Now you can tell me an additional step was not the idea, but the beauty of it is that you then can really transfer ownership only via a blockchain transaction. And that is the interesting part, because then you have a digital transaction which in the end result in a transfer of a right. And that was the idea, to have legally enforceable digital transactions. Because if you think of blockchain technology as one of the technologies which are used for digitalization and digitizing our economy, because you can easily transfer value, you have to have legal certainty. You have to have legal enforceable claims. So that was the idea. We said, okay, if you have a blockchain transaction, a token representing ownership rights, for example, if you want that people are using that, if something goes wrong, they have to go to a court. They have to be able to go to a court and with legal certainty know that in most cases they will win the case and they are able to enforce their rights. So what you need for that is, as I said, you need this trustworthy technologies, this transfer on a trustworthy technology, also known as blockchain or DLT, some selected one. That's actually also very interesting. So we came up with this idea of trustworthy technology to be technologically neutral and agnostic. There's a lot of research done around the area. What is a sufficient level of decentralization? We had some thoughts on that already quite early, but this is a very interesting area, because if you analyze our approach in depth, this is one of the core principles. You have to have a trustworthy technology to allow you for all of the legal consequences based on our law, because it is actually huge. You can transfer a lot of rights via blockchain with our law, but therefore this has to be a technology where you don't have to trust an intermediary, and which actually addresses the normal risks you have with these transactions. So we have this TVTG framework, which then in Article 7 states that if you transfer, basically in a nutshell, if you transfer the token, also the represented right is transferred. And if that is not, if something goes wrong, you should be able to go to a court and then get this enforcement. Key takeaways. So first of all, I think in a lot of areas, we need new regulatory approaches. Don't just regulate without fully understanding this technology, I don't consider that I fully understood this technology, but in the end, at least understand the basics of this technologies, because otherwise you will kill a lot of the innovation. And whenever there are bad cases, and we do have some bad cases, this will trigger bad regulation if you don't do your homework first. Secondly, we came up with the idea of representation of rights. That is a very unique approach, I think, here in Liechtenstein when it comes to blockchain technologies. And this allows you for tokenization of assets in a very secure way and in a very, very efficient way, because you get rid of intermediaries, you get rid of SPVs. And actually, I did not mention that, so I want to do that now. This is also used at the moment already by intermediaries here in Liechtenstein when it comes to inheritance. So if there are banks in Liechtenstein which book you tokens in your portfolio overview, and if it comes to inheritance, you don't have to sell, for example, the piece of art. You just issue 10 tokens and then you divide them to the heirs, and you don't have to sell it or do whatever. Give it to one person and then all of the others, they're angry. So this is already used on here in Liechtenstein. And then third, yes, you don't need a legal framework for tokenization, but you need this legal certainty. We came up with a legal framework which is suitable for our civil law jurisdiction here. And I think the basic concept is an interesting one and can be used in other countries as well. We also have an example of how you could make this law applicable for other transactions if your local jurisdictions allow for that. I briefly talked about the book recommendations. The blue one is the PhD I was talking about, The Legal Nature of Tokens, which also talks about decentralization, what is trustworthy technology, and in essence really talking about the definition of what a token is, and then also covers the tokenization of assets when it comes to real world properties with examples, for example, how you can tokenize a snowboard rental company. And the other book is Open Access. You can just follow the link. That's a book about the secondary market for a security token. We briefly touch on securities. If that is of interest, please follow the link. We also do, as I said, do research in that space and publish them online via our social media channels. So if you want to, you can follow us there. And if you have any questions, you can always drop me a line to tian@nägele.law or visit our blog, our YouTube channel, where we do publish quite a lot. Thank you very much for your attention. And I think if there are specific questions, you can always directly come to me via my email address, or I think that Jason is happy to collect them and then forward them to me, and I'm trying my best to answer all of them. Thank you very much again for your interest, and I hope that if I'm going to be invited again, that I will be able to make it to Australia, because that would be a big pleasure, or at least to have a live session with you. Thank you very much and have a good day.